Well, 3.5 million unmarried South Africans who live with their partners have never had legal recognition upon their partner's death. But a recent Constitutional Court ruling is compelling the law to change. Parliament has until the middle of next year to amend 2 acts to include all life partners in the definition of a spouse. This has the potential to have a major impact on the legacies of unmarried South Africans. As many as 80% of South Africans have no will. Well, David Thomson is a senior legal advisor at the Sanlam Trust. David, thank you so much for joining us. Interstate succession. I mean, interstate is when you don't leave a will. The Interstate Succession Act means that there's an automatic claim to an estate. Can you just tell us how the Constitutional Court ruling is changing that for what many South Africans thought was a common law partnership, but in fact it didn't exist in SA law?
Yes, that's correct. Marriage is regulated by statute. Though, of course, we do also recognize marriage by religious rights in certain circumstances, but there is no such thing in law as the common law marriage. You're either married or you're not. And the impact of the Constitutional Court judgment is that, in their view, aspects of the Intestate Succession Act and the Maintenance of Surviving Spouses Act are unconstitutional because those acts do not protect a life partner in a heterosexual relationship.
Let's talk about the fact that the Maintenance of Surviving Spouses Act is also due to be amended. How does that affect people in relationships?
Yeah, so it actually means up to now, if you're living with someone, you do not have the right to claim maintenance from their estate, even if they leave you nothing at all in their will. And of course, if they die without a will, you're not going to inherit anything because you don't qualify in terms of intestate succession. So what it does mean, it gives the potential now for persons who live with another person where that other person passes on to put in a claim against their estate, based on their need and based on their life expectancy, based on the lifestyle that they're accustomed to. And that would obviously be a claim against the estate, which might then outrank claims by other heirs and family members.
I think the original case was brought by the Women's Legal Centre in the case of Ethel Robinson, where she'd looked after an ill partner for many years and then received a very small amount from the deceased's trust, and it was actually the family who were opposing that. So that has been overturned. It's about time. It's been many, many years since then. What about same-sex couples?
The same-sex couples, of course, they can marry now in terms of the Civil Unions Act, but in terms of Gorey versus Culver, when that Constitutional Court case was decided, they were not able to marry at that time. So the court came to their rescue and said same-sex couples have the right to inherit in terms of intestate succession and also to put a maintenance claim. But at that stage, it didn't apply to heterosexual couples because heterosexual couples can choose to marry or not marry and have always had that right to do so. So for same-sex couples, if you also look at the recent Supreme Court case of Duplan, they have the rights to claim. But this creates new rights for heterosexual life partners living in a relationship together where they've created reciprocal rights and duties of support. So it really does open the door up to probably the vast majority of people that are living together and haven't formalized it with a ring on the finger, as it were.
Last quick question here. What about when there are heirs involved?
Yes, absolutely. If you die intestate, your estate is shared between spouse and children. Up to now, a live-in partner wasn't declared a spouse. So it now means that if you die intestate, your estate will be shared potentially with your live-in partner if they can prove that they were in a permanent relationship with you and your children. So, but if you have a will, of course, you're entitled to leave your estate to whoever you want. So it's wise to have a will, make provision for your live-in partner, because it's going to take 18 months to 2 years for Parliament to change this law in any case.
All right, that was David Thomson of Sanlam Trust, and as he says, make a will.